Okay, so we're in the final video here in a series on the protections contained within the Dodd-Frank regulations. That's the Consumer Financial Protection Bureau's Help for Struggling Borrowers and Guide to the New Mortgage Servicing Rules that are effective on January 10th, 2014. Now, in these prior videos, we talked about the way these regulations were enacted by Congress and then put effective through the Consumer Financial Protection Bureau and how they're brand new. It really resulted in a complete change of the landscape and really a breath of fresh air for both the servicing industry and consumers. They provide very robust protections for consumers, great responsibilities on the hands of the servicers, but in the experience of practitioners like myself, the servicers are in many ways stepping up to their requirements under the CFPB and engaging in the kind of robust communication that the banks should have been doing long ago, but now that they are doing that, we got to give them credit for that. Again, very effective in my experience that the banks are working together with consumers. The problem is, in this current environment of the foreclosure purge here in Florida, they're not being given credit for that, and in fact, we are running into great conflict with the court system. So what happens when a consumer has a loss mitigation application pending or a formal modification that they've entered into, and they stand before the court with the bank standing there, and the bank says, "Judge, please, we don't want to go forward to sale, or we don't want to go forward with the trial," and the trial judge says, "I don't care. I've got this mandate. The mandate says we're going forward to trial because we're going to clear this docket, and that's all that matters." Well, that's not all that matters. Again, all hope is not necessarily lost, even when that consumer loses at trial, which, you know, given what's happening in the state court system, that in many cases is a fait accompli, even if you've got really good defenses. But let's say you go to trial and the consumer loses and a foreclosure sale is set. Well, obviously that's a very anxiety-provoking event when you've got a sale set. You should absolutely consider bankruptcy to stop that sale from going forward. But even if that's not an option or you don't do that, coming up to sale, what the consumer needs to be doing is very assertively and specifically making those Dodd-Frank protections work for you by making complaints and keeping good documentation of what the consumer's done to enforce Dodd-Frank and maybe get a modification, and quite frankly, for the bank to be able to document what they've done to try and work with that consumer if that's the case. But assume that all has gone wrong and we've got a sale date scheduled. Obviously, that's a crisis event in the family, a crisis event for the bank in many instances. Well, we got to alert the court to this crisis event. The bank and the consumer should be making multiple attempts to get the sale canceled. But then what happens when the judge says, "Too bad, sale's going forward"? Well, at that point in time, the bank can take certain maneuvers behind the scenes to, say, prevent that house from going to a third party, and they're doing that. That's another one of the backstories in foreclosure, is that the foreclosure auctions that are operating across the state of Florida are not public events. Well, they're public auctions, but the way they're being manipulated renders them not really a true public auction, specifically because in something like 80% of the cases, the bank takes the property back as opposed to letting like a third-party purchaser get those. Again, that can be a good thing for a consumer. So the judge refuses the motion to cancel sale. Now the sale goes forward, and Bank of America has now taken back possession of that property or title to it as a result of the foreclosure sale. Again, another important point that the consumer needs to be asserting those Dodd-Frank rights. They need to be asserting violations of CFPB. They need to be keeping very good records and making the court and making the bank aware of the fact that the sale represents a violation of Dodd-Frank because of what's occurred. What we're talking about here is an emergency situation, and what we're talking about here is invoking the terms of Dodd-Frank to try and prevent that catastrophe, that chaos that results if the sheriffs show up at a house and say, "We're going to throw all your stuff out into the street because we're going to issue a writ of possession." Now, again, the protections contained within Dodd-Frank should prevent that, but this is no area where a consumer should be going it alone. This one in particular is where when that wolf is at the door, when you've got a trial, when you've got a summary judgment, especially when you've got a sale, you need to speak with a competent and experienced consumer defense attorney and either consider your bankruptcy options or consider those options under Dodd-Frank. I hope you'll give us the opportunity to work with you. If you have any questions, please give our office a call or shoot us an email. We'll be happy to help you out with that and give you all of the Dodd-Frank regulations in this important brochure, Help for Struggling Homeowners. Thank you.